Thank you very much, Roxanne, and thank you as well to the organizers for having invited me to what has proven to be a really interesting meeting with a lot of great discussions around open science. So I'm from the discipline of law, and lawyers like disclaimers, so I'm going to start with a disclaimer. Yesterday, for your keynote, you had the young, enthusiastic scientist. Today, you're going to get the old, cynical lawyer. So there you go. I found this presentation really challenging to put together, and after struggling with it for a while, I had to sit back and ask myself, why am I having so much trouble with it? And I think one of the reasons why I'm having so much trouble with it is because I think in the end it's because I see us in a state of transition yet again. And I'm going to explain that because I'm going to talk in the presentation a little bit about the historical context for how we got to open science with the role of intellectual property law in getting to open science. And I think we're at another moment of transition or change. So just to quickly, in terms of an overview, I am going to talk a little bit about the historical context of IP law and the academy, about the impact of globalization and technological change, because I think this has played a very significant role, and as I've just alluded, is going to play one in the future. The evolution of open science and the role of IP in it, and then IP for ethically open science. The Foster Open Science Taxonomy I find really impressive in terms of just the complexity of it. I think it illustrates fairly well the complexity of the project of open science. And there are a lot of moments in that taxonomy where there's reference to different policies, and law often underlies many of those different policies. The Foster definition of IP is legally recognized exclusive right to creations of the mind. And while I don't disagree with that definition, I find it interesting that it refers to legally recognized exclusive right. In fact, it's legally fabricated exclusive right. These exclusive rights are made by the legal system and exist as a result of the legal system. And I think that's an important thing to keep in mind, that these are themselves creations of law and politics. So I'm going to focus primarily on copyright law today, although there are other areas of intellectual property law that are relevant to open science generally. Because this is a digital humanities group, I'm going to talk primarily about copyright law. Happy to talk about the other areas of IP law and questions if it comes up. And copyright law, as you probably all know, attaches to literary, dramatic, musical, and artistic works, broadly defined. Those categories are very broadly defined and can include maps, photographs, charts, diagrams, software, compilations of data, and so on. One of the important and challenging things about copyright is that no formalities are required. And so in that sense, it's different from patents or trademarks. Nobody gets a patent by accident, right? You have to actually apply, you have to pay fees, it's a long and drawn out process, there's an examination. And while it's possible to have unregistered trademarks, again, for registered trademarks, you have to, there's intentionality. You have to decide that you want that type of IP protection, and you have to go through the necessary steps to get it. Copyright arises without, in many cases, without people being aware, wanting it, needing it. And so, for example, if you're sitting there doodling during my presentation, at the end of my presentation, at the end of your doodle, you'll have copyright in your doodle. And, you know, for what that's worth, it just arises automatically. And because it arises automatically, it is very difficult to manage, because there's copyright in so many things. When you start pulling them together, bringing them together, when you get multiple participants engaging in different projects, you start to get rights accruing that you may not be aware of. And so I compare copyright to cat hair on a dark suit. Right? It just appears out of nowhere, and it's really hard to get rid of, and you have to stay on top of it to manage it properly. I also want to say a word about IP rights and cultural specificity. I mentioned before that intellectual property rights are actually created. And the intellectual property laws that we have currently are shaped very much by the rise of individualism in the West and by the development of capitalism. And so those influences are very present in our current IP laws and have a significant influence on those IP laws. Western notions of IP are a poor fit with oral traditions, with communal or community-based ownership, and with the protection of cultural expression from outside exploitation. So it works with individual creations. It doesn't work as well with communally created works or with different forms of cultural expression. And so this can be a real challenge in terms of ethical IP and ethical open science. So it's important to remember that open science has been built largely within a Western IP law framework. And I think it's important to be cognizant of non-Western systems of knowledge, which may provide alternative models, for the development of knowledge and for the creation and sharing of cultural expression. And again, this may involve adapting or changing licensing practices. And I think one of my takeaways perhaps is going to be that one size doesn't fit all in terms of open science, that different types of works, creations, expressions may require different approaches to licensing. So just a little bit of the historical context, which I think is important, at least for me, to understand what's going on. Science was not always open, obviously, as we know. We're moving towards some concept of open science. Paul David, in his work on the historical origins of open science, talks about the scientific revolution in the late 16th and early 17th centuries, leading to, and I quote, a transition from the previously dominant ethos of secrecy in the pursuit of nature's secrets, which gave way to a new set of norms, incentives, and organizational structures. And he talks about how these institutional transformations reinforce scientific researchers' commitments to rapid disclosure and wider dissemination of their new discoveries and inventions. So he talks about this age of greater openness in science. Interestingly enough, that period also coincided with the birth of modern IP law, essentially. And what you see with modern IP law is this shift from fairly arbitrary royal privileges or monopolies to a system that put rights in the hands, very temporarily, of authors and inventors. And this was these were interesting innovations or changes in the law. And some of the features that you see at this point in time that were quite important, first of all, is you have a limited period of monopoly. The royal privileges could be perpetual or they could be at the whim of the king, but with copyrights and patents, you got a limited monopoly. And that would come to an end at a certain point. There were also clearly certain things that were excluded from the scope of monopoly, so you couldn't have monopoly over facts or ideas. The laws also set conditions for the grants of rights. So you had to meet certain preconditions in order to receive a patent or copyright. And both patents and copyrights were intended to provide incentives to authors and inventors to create and to innovate. With that incentive came a quid pro quo, which was meant to serve the public interest. And so with patents, the quid pro quo was disclosure. You had to disclose your invention, so there's an openness there. You would get your patent protection in exchange for this disclosure. And for copyrights, it was both space for the public domain and users' rights. And the public domain, once the term of protection was open, the work was freely available within the public domain. And so these were exchanges within the legislation, and I think they were fairly important ones. But what you see is this system that creates a certain balance. And it was necessary at a time when the infrastructure required for information dissemination was extremely expensive and not very widespread. So if you were going to publish a book, it had to be through a printer, and the printer had to have physical premises in which to locate the printing press, and had to have a printing press, which was an expensive piece of technology, and there had to be people to operate the printing press and to engage in all these. And so it was a very expensive proposition, which required a considerable investment. And without a royal monopoly or royal privilege over certain key works and so on, it would be very difficult to make that printing business viable. And so the system of copyrights was intended to promote the dissemination of works, which is one of the values of open science if you think about it, by ensuring that the printers could have the revenue streams that they needed to continue to operate. And so the author would get a copyright, the author would very quickly transfer their copyright to, or assign their copyright to, a publisher. The publisher would publish the book and would have the copyright, which would be a limited term monopoly, which would guarantee them a certain return on their investment for printing the book. And so in a sense, if you think about it in that way, the original intellectual property laws were intended to foster greater dissemination by paying for the infrastructure that was required to achieve that dissemination. This is just from the Statute of Anne, the first British copyright statute, and it says, I don't know if it's easy to read, an act for the encouragement of learning by vesting the copies of printed books in the authors or purchasers of such copies during the time they're mentioned. So that was really very explicit in the Statute of Anne. This was to promote knowledge and learning. What it led to was the situation that we are all familiar with, which is publishers, even so many years after the Statute of Anne and the Industrial Revolution, authors giving their entire copyright over to publishers or to printers. So this became the standard, the convention in the industry. Unless you were J.K. Rowling or somebody really famous, you had to assign your entire copyright over to the publisher, and then the publisher would do what they would with it. And so this is part of what led us to the problem that we have prior to open science. It's only part of it because that model used to work. What made that model not work as well, of course, was globalization and technology. And so the globalization, of course, had a number of relevant impacts, but one of them was just with the rise in importance of intellectual property assets was the globalized trade in intellectual property assets and the need to protect them. And so you start to see in 1994 in the TRIPS agreement, for example, intellectual property becoming an important feature of international trade agreements. Since then, intellectual property is a major part of every trade agreement, and there are constantly attempts to ratchet up the level of protection for intellectual property in these trade agreements. So you have a ratcheting up of the protection of intellectual property, in part in response to the other phenomenon, which is massive technological change. And this is because technological change has threatened established intellectual property interests and led them to put pressure on national governments to increase the amount and type of protection. And I'm going to suggest that the era of technological change that we're in right now, the next phase, the new one, is big data and artificial intelligence, and that these are going to have similar transformative changes, but I'll come to that later. So once you start getting this technological development, these are like really old technologies, but they were transformative. These were the first technologies where the tools of reproduction were put into the hands of ordinary individuals, right? So, before you have the publishers, you need infrastructure. If somebody's going to be a pirate or pirate works, they also have to have similar infrastructure. But all of a sudden, mass market technologies became available, which enabled people to copy things. And the first response of copyright holders, industrial copyright holders, was to sue, to try and suppress the technologies. And so these are from a couple of cases, one from the US Supreme Court about the Betamax, of all things, and the other one from the House of Lords in the UK about high-speed dubbing, a transformative technology, truly it was, which is long dead. But these were attempts essentially to say the companies selling these technologies were the argument was that they were authorizing infringement by selling technologies that would allow individuals to make copies of works. And fortunately, they lost. Both courts were very reluctant to put the brakes on technology, to label a technology as problematic. And the idea was you have to focus on the uses that are being made of the technology. And this, of course, is the other technology in the academic context that was so disruptive, which is the photocopy machine in the library. And there was litigation again, one of these cases from the High Court of Australia, another one from the Supreme Court of Canada, litigation about whether libraries were authorizing infringement by putting a photocopy machine in a library full of books. Was the library just kind of egging people on to infringe copyright? And the Australia High Court said yes, the Supreme Court of Canada said no, although notice the difference in time period between the two. And so this was, again, another part of this battle over technologies and what the impact of technologies were, and you have the industry pushing back. The next phase, of course, these were technologies of reproduction. The next phase was technologies of dissemination, the internet, the World Wide Web, when all of a sudden, not only did it become easy for consumers to make their own reproductions, but it became easy for anyone to also widely share and disseminate those. And that's when you see, again, a further pushback of industry branding everyone as thieves and pirates, and starting to litigate or to pursue individuals for infringing copyright and being engaging in piracy. And so you start to see this negative messaging about copying and this attempt to stop people from engaging in these activities. And this is really where you start to see the pushback against this resistance by industries to the technologies of reproduction, the technologies of dissemination, as well as the pushback against the established industries controlling so much of knowledge creation and dissemination. The other phenomenon, I'm sure you're all familiar with this as well, is that with the rise of these new technologies, you start to see the disappearance of physical copies of works. And so people are no longer acquiring physical copies of works. What they're doing is they're licensing digital copies. And so you start to see, again, the rise of the license as being an important tool for controlling how people use copyright-protected works. The problem or the challenge with the license, of course, is that the license is just a contract, and copyright gives lots of room for modifying the basic default rules by contract. And so in the licenses, you start to see restrictions on users' rights, on fair dealing, and other legitimate uses of works that used to be acceptable with physical copies. So you get an even greater crunch on the ability to make use of works through the license agreement. So academics then take control. And this is where you start to see the rise of the open movements. And the idea was not so much to abandon intellectual property rights, but because, especially with copyright, because it could happen without any intentionality. So the idea was to manage it, and to manage it in the public interest. And so you start to see the development of these simple, user-friendly tools like the Creative Commons license, which would allow anyone who had created a copyright work to license it in an open way to a greater or lesser extent, because there was a suite of licenses, and to take control over their copyright. And so that eventually led to these new opportunities for open access publishing, the creation of new journals, the creation of digital repositories, as you start to see people taking much greater control over how their works were to be shared with the public. And then eventually you see granting agencies coming on board to provide a new impetus for open access publishing and open access funding or support for open access publishing. And so obviously there's a real stake there for academic creators and users of copyright. We found ourselves in the situation where we were creating works that we then had to charge our students for if they were works were going to be included in course packs, and our libraries were paying for those works. And then there was an extra levy fee on the photocopies that were being made of those works in the libraries. And those works were being paid for by students and libraries and faculty members over and over again and many times, and it just didn't seem to be to make sense anymore. So this is where you get open access. Now the open science movement takes it another level and looks at making open not just publications, but research data, materials, making peer review open. And so it's much more ambitious in many ways than simple open access. And because it's much more ambitious, it's also much more complicated. It raises issues of standardization, interoperability, archiving, the development of appropriate metadata, all of those things that you're very well familiar with. It also raises more complex questions of confidentiality, privacy, ethics, and so on. So the Open Science Project is suddenly a much bigger and much more complicated project. Now the other thing, and I'm just going to take a little side trip here. I think the other phenomenon that arises at the same time that you have this proliferation of technologies, both of reproduction and dissemination, is a process of democratization and self-determination, which I think is also important as well. The conventional modes of academic publishing supported the creation of academic elites and created barriers to access to knowledge based on status and privilege. And so, it was really only a select few that had reasonable access to the journals and the expensive journals and the expensive books that were being published and stored in academic libraries. It created these barriers within any given society. So, within a single country, there would be these barriers, these elites and these barriers to knowledge, but it also created very significant barriers across north-south boundaries. The books that were being published in Western countries were simply unaffordable in the global south. So a more radical dimension of open science is the opening up of scientific engagement and activity to amateurs, to so-called amateurs, who are now able to, or with the technology that's available to them, to engage in a very broad range of activity that used to be the province of the elites. So it's not just access to the science and the published and the research materials, but it's also now access to technologies. So if you think about your cell phone and the sophisticated piece of technology that is, it reads GPS coordinates, it's a camera, it's a video recorder, it's got all of this technological capability, and it's very widely dispersed as a technology and very accessible. And so you start to see ordinary people engaging in science and in research activities in all kinds of new ways. And so one example is, and I take it from geography, neogeography. And here's some descriptions of neogeography from geographers, a remaking of the bounded knowledges and skill sets around which these disciplines have conventionally been conceived. Geography without geographers, that's from Daniel Suey. And my good child, neogeography is characterized by a blurring of the traditional roles of subject, producer, communicator, and consumer of geographic information. So you start to see the shift and breakdown of who is actually creating knowledge. And you see it in a number of different ways. The other thing that you start to see, or one of these manifestations, I guess, is citizen science, which has a number of different labels: public participatory research, volunteer monitoring, crowdsourced science, democratized science. And so you start to see the citizen science movement take off. The citizen science movement is really interesting because there's such a breadth of involvement of the public in citizen science and such a breadth of ways in which it takes place. So you have some where, like old weather, where people are basically recruited to digitize the handwritten ship's logs of captains from the 17th and 18th centuries, and to create digital records so that we can get an understanding of the weather conditions. Because captains, it was kind of important if you were sailing a ship, and there were good records kept of that. And so the citizen science in that case are basically just scribes. They're writing out what they see in the logs. In some projects, like Galaxy Zoo, citizen scientists look at and interpret what they see in a vast trove of images. In other ones, they're invited to go out into their environment and record findings. This is the ladybug project. They're looking for a particular species of ladybugs and asking people to photograph it with GPS coordinates and send the data in. So it's data collection through citizen science and the scientists in the field. There's a very broad range of citizen science type projects. A lot of citizen science projects, particularly at the outset, were top-down, but not all of them were. Some of them were non-expert-led. And so this is part of this is neogeography. And again, a quote from Mike Goodchild, the world of authoritative geographic data is being rapidly augmented and to some extent replaced by a new world of asserted geographic data. The old distinction between the non-expert amateur and the expert professional is quickly blurring in this arena, since few, if any, of the arguments that built and sustained the traditional system of map production are now viable. And so you start to see projects like OpenStreetMap, which is gaining in credibility and gaining in use, which is really just crowdsourced mapping. And there's Wikimapia and other such projects. These are not top-down in the sense that they're not conceived of and led by researchers within university environments and controlled. They're basically projects of the crowd. And so this is an interesting development as well. And another thing that I want to flag is the extent to which citizen science can shift the traditional paradigm for scientific research, wherein the goals of a community may be more important than the academic researcher's goals. And so this may be the case in public participatory research as well. It also may be that the goal of the research project is not so much to produce research results, or the primary goal, research results in the conventional way, but the goal is to engage the community, teach, get people interested in science, help communities to better their living conditions. So there may be a different set of goals, and research is not the primary goal. And this can raise interesting questions about how you manage intellectual property rights within this context, where the goals of the project and who's leading the project and who's involved in the project and the extent to which they're involved can shift quite significantly. And so certainly in the realm of citizen science, you start to see interesting questions about the status of citizen science participants in the IP paradigm. Certainly not in all projects, but in ones that are less top-down, you start to get these questions being raised. The other thing I want to mention is the indigenous data sovereignty movements, which are taking place. You may be less familiar with them here, although you may also be familiar with them through your work. But they're becoming quite important in Canada, the United States, New Zealand, and Australia. And in these movements, there is an insistence on new roles for communities in the design of research projects and in their implementation. And it's a real shift in power dynamics between professional researchers and communities. And as a result, there's also a need to reconsider the location of intellectual property rights in outputs. The traditional models of creation of academic knowledge were ones which tended to marginalize indigenous peoples. At the end of the day, the communities often had no access to the research data or the research results, which was very problematic. And as well, intellectual property rights could arise in very problematic ways. I'll just give you one example here. The photograph on the right, anyway, the photograph on the right, I think it is on the right, the older photograph, was taken by a researcher in an Inuit community and was published in a book. Now, the photograph having been taken by the researcher would have held copyright in the photograph, and the researcher or the publisher would have had copyright in the book. The man wearing the jacket who designed the jacket based on a dream that was sent to him by his ancestors would have had absolutely no rights whatsoever in any of it, including in the jacket, because the intellectual property rights system just can't deal with communally owned property and stemming from oral traditions and also manifested in this particular way. A fashion designer, found the photograph in the book and created that garment on the other side. This raised a hue and cry in the Inuit community in question. But there are not a lot of legal remedies for that. But it's just an illustration or example of how the dissemination of research in some contexts can be extremely harmful and can have unintended consequences. And the location of intellectual property rights can not only not be helpful, but can actually be unhelpful. And so I just use that as an illustration because I think that when we talk about open, and I'm going to come back to this, open in the open science, open data, open access, and so on, there are some contexts where open may simply just not be the right thing, and where ownership shouldn't be, or the decisions about openness shouldn't be located or situated with researchers as opposed to communities. There's some really interesting work being done on Indigenous data sovereignty, essentially taking control of data about Indigenous communities, but from the point of conception of the study. So it's very much about sovereignty over the data that is being collected about Indigenous communities and requirements that it be only, not just the old consent model, but that actively involve capacity building and training, and that the information be given back to the communities, and that the communities control the dissemination, both the storage of the data, but also the dissemination of the data. So there's a lot of interesting work in that regard as well. So that brings me to, challenges for ethically open science. I've sort of given you a little rambling tour of some of the background and the context. And now I'm going to try and get a little bit deeper into some of the particular challenges. One of them is, and I've already alluded to this a few times, is authorship and attribution. So under copyright law, the author is the first owner of copyright, except when they create works in the course of employment and subject to agreements to the contrary. And so this is obviously something that has to be thought through and managed. If you're employed by a university, then in theory, the university is the owner of copyrights in your work. Usually there's a collective agreement that sorts out that sort of thing. But there can be lots of different relationships in which the control over the copyright is allocated differently. And of course, who owns the copyright is really important in determining who gets to exercise the copyright. Where you have co-created collaborative works, it can be difficult identifying or thinking about where authorship is located. And this is particularly challenging in some citizen science contexts. In some of them, they're fairly top-down projects, and so the authorship tends to be located with the researchers, the university researchers. But in others where there's a high degree of collaboration or involvement, there can often be sort of debates and discussions about whether attribution is required or whether the contribution amounts to ownership, and if it does, how do you, or authorship, and if it does, how do you deal with any intellectual property rights that flow from that. In terms of who is the owner of copyright work, another issue is whether there may be a fiduciary element to ownership. There's certainly some case law from Australia that talks about a fiduciary element to ownership in the case of intellectual property in works created with permission of Indigenous communities. So the author of the work who had permission to create the work owes a fiduciary obligation. The community still doesn't have copyright because copyright can't deal with that kind of thing. But then there may be a fiduciary obligation on the part of the creator of the work to respect the wishes and the trust that was placed in them, and that might actually be enforceable in the courts. So that's an interesting thing as well. And you can think about it in the context perhaps also of citizen science. If you've involved participants in your project, and do you have a fiduciary obligation, for example, to ensure that the data flowing from that project is publicly available and easily findable and preserved for posterity, or whatever you want to call it, archived and kept. And so the fiduciary question is interesting. It's underdeveloped, but it's an interesting question. And how do you provide attribution for contributions other than authorship? And this is just an example from Massachusetts Audubon project where a particular form of attribution was decided to be appropriate for all of the different volunteers that had participated in the citizen science project. So it's just an illustration. A second issue is authority and authenticity. The open access movement has given rise to, as you know, predatory journals, multiple information sources. We live in an era of fake news. Authority of information and authenticity of information are really challenging issues. And of course, you need trust systems for open science. And some of the discussion has been today, for example, and peer review and so on, has been around building appropriate trust systems for open science. I'll just mention briefly, I don't have time to get into it, but another authority system is trademarks or brands. And there may be things that can be done around building or leveraging institutional or other brands and doing so more mindfully. One of the reasons why top journals can continue to charge people outrageous funds to publish in their gold open access is because they're top journals, is because of the reputation that attaches to the brand and the reputation, prestige that attaches to them. And so building trademarks or brands and maintaining them and managing them may be another way for alternate forms of open access publication to succeed. In terms of authenticity, attribution requirements may be relevant, and this is in license agreements. Limits on representations, limits on derivatives. And so I'm just going to show you an example of a license that has done these types of things. And this is controversial in the open context, right? Because the more conditions you put in licenses, the less interoperable they are, and then the more unwieldy they are to manage. On the other hand, if you don't put conditions in license, how do you manage things like authenticity and authority? So this is a license agreement from Statistics Canada. I'm sorry, it's probably a little hard to read. I've underlined the parts where Statistics Canada is trying to ensure that although the statistics are made available under an open license, that they're used in responsible ways. So the information has to be reproduced accurately, can't be used in a way that suggests Statistics Canada endorses you or your use of the information. You can't misrepresent it. Now, maybe it goes too far, but I thought I'd include it as an illustration of how license terms might be used as a way of trying to reinforce authority and authenticity for certain types of information. Another issue is sustainability. Open access, we heard yesterday open access is free. Why aren't more people doing it? Open access is not free. It's really, really, really expensive. And so this is a huge challenge. Currently, the costs of open access, open science are being borne largely by the public sector. And so one of, I think, the big questions is how durable that commitment is. In some countries, in some regions, it's going to be more durable than in others. But I worry that open science is actually very fragile to the extent that it is completely open and built on public money. In my view, something is going to have to give at some point. And if it does, then is there a risk of just losing content? Repository shuts down, closes its doors. Do we lose stuff entirely? Or is there a risk, and this one worries me, of privatization? Elsevier bought SSRN, the Social Sciences Research Network, which was an open access repository that had been running for years and that so many of us had contributed our publications to. And then we woke up one day and it was purchased by Elsevier, which promised that, oh no, everything's fine, don't worry about it, right? It's going to keep being open. Nobody trusts that. And B, there may be other monetization of the repository that's being done by Elsevier, particularly through big data analytics and selling those analytics back to universities and to employers about the people who are using the repository and how often their articles are read and so on. So it's a risk and something that needs to be thought about. And Rob Kitchen and others wrote a nice piece on using, he didn't actually write it about using intellectual property rights. He wrote it about funding models for open access digital data repositories. So a thoughtful piece about different ways in which you can monetize repositories. You can do that through IP rights and the licensing of intellectual property rights. And I think that it's something that open access repositories are going to need to think about, which is, you know, do we charge, is it free for non-commercial use? Free for university student access, and paid for commercial use. And is that on a scale so that small startups pay less than big corporations? So I think it's important to think about risks and consequences of other funding models. And IP rights and licensing can play a role in that context. I found this in the Horizon 2020 grants manual. I thought it was interesting. The part I underlined is, well, the quote says, the Commission considers that there should be no need to pay for information funded from the public purse each time it's accessed or used. That's a nice principle, right? Moreover, it should benefit European businesses and the public to the full. And I'm not picking on Horizon 2020 or the European Union, but I do find it interesting that businesses come first. And I see this in open government data, and I see this in other contexts as well. I am really concerned that open science has become the handmaiden of neoliberalism, and that what we're really doing is providing an enormous free subsidy to large corporations. And this is where that other piece that I mentioned, the fact that we're in this big data, artificial intelligence, massive shift in the economy and in technology, that these free open repositories are essentially providing fuel for the private sector in these models. And on the one hand, we should be supporting to some extent innovation and happy when our societies do well. On the other hand, why is the public funding and throwing so much money, and why are we all putting so much of our time and energy into these things that are being essentially exploited by the private sector, and often by very wealthy private sector corporations who aren't necessarily putting things back in? So then again, when you think about funding models, perhaps an information tax, I mean, how do you make it sustainable so that it doesn't just become a free business resource? New uses, I think, are interesting. There are, of course, now these new ways to conduct research and generate insights and to innovate. There's a debate going on right now worldwide, but particularly in the European Union, around text and data mining and whether text and data mining is copyright infringement. I think this is an interesting question, and it's an interesting question for open repositories as well, because, again, this is content that may be taken and used for text and data mining. And so what that exception says is going to be relevant to how things are used. I'm running out of time, so I'll just very briefly say that I think that it may be, under the current wording of the exception that's being proposed in the EU, it might be impossible to limit text and data mining by license. In other words, you won't be able to put in a contract that these works should not be text and data mined. There's so much that you can do with text and data mining and artificial intelligence, and some of it might actually be harmful to communities, harmful to particular cultures, problematic in some respects. And so it's interesting that there might be a text and data mining exception to copyright infringement that doesn't allow restriction by license. So I'm just going to flag that as kind of, again, something that's coming and something that's interesting and something that we have to think about in terms of digital data repositories. The other thing about, and this is my last slide, is that I want to flag as well open science private data. And this is a phenomenon I notice. It's perhaps more important in the social sciences than in the humanities, But important data and data sources are increasingly in private sector hands, and academics are going to those sources of data that are in private sector hands. And so social media data is a big one, platform data, Airbnb, Kickstarter, Facebook, all sorts of platforms, Pornhub, Google, all of these platforms, no, really, they make their data available, or at least a subset of their data available to researchers through an API. And researchers are mining that data and doing lots of work with that data. If you want better access, you have to pay an additional amount. And so it's a concern for me that there's so much research data that is now in the hands of the private sector. On the one hand, we are opening everything we do up and giving it away for free. And on the other hand, the private sector is giving us a taste for free, and the rest if we're willing to pay for it. So I think that's really another issue that I want to flag here. How should access to data be managed by the private sector with respect to academic researchers? How should copyright policy address academic researcher access to private sector data? Especially in a context in which we're also seeing, again at that global trade level, a new push for greater intellectual property protection for data, which is the fuel of this new economy. And I think that's something that we should all be wary of and be ready to push back against if it comes to the trade table negotiations. So that was very briefly me flagging a whole range of issues. You can see why I had trouble. There's just a lot of stuff going on, a lot of things to be cognizant of. So I'm going to stop talking now and throw it open for any questions that you might have.